So I'm going to pick it up on the a briefing that you wrote on, or that you, from you anyway, the 10th of March 2009. That's MHRA 0024725. So we've got here, it's from you, 10th of March, to Penelope Irving and Morven Smith, briefing for meeting between Secretary of State and MSPH and Lord Archer on 11th of March 2009. Is it right to understand that the two recipients of the briefing are the private secretaries of the relevant ministers?
Yes, that's right. I can't remember. Morven Smith was the Assistant Private Secretary, I think, as we said earlier, to Dawn Primarolo. Certainly Penelope Irving was in Secretary of State's private office, yes.
And then we see at paragraph 1, what the purpose of the briefing is. The Secretary of State and Minister of Health, Minister of State for Public Health, are meeting with Lord Archer on Wednesday 11th of March to discuss the report of Lord Archer's independent inquiry into the circumstances surrounding the supply to patients of contaminated NHS blood and blood products and the consequences for affected patients, particularly the haemophilia community. The report suggests further steps to address the needs of patients and bereaved families. And then you say, as requested, and then you set out a number of annexes that you've obviously been asked to provide. Is that right?
That's correct, yes.
And then you also attach a chronological narrative we see from paragraph 3. It was, if we can just, then you set out parliamentary interest and activity. So you set out topical questions that have been asked in the House of Lords to bring, presumably, the ministers up to date. And then if we go over the page, please, we can see further information about EDMs being laid, early day motions being laid, and then at paragraph 7, you refer to the public inquiry chaired by Lord Penrose being convened. And then at paragraph 8, you set out the government position. And I just wanted to ask you about the first 3 bullet points in relation to that. So you say this: the position of this and previous governments is that this is a tragedy and there is every sympathy for those infected. However, it is important to remember the following points. And you say the treatment given to haemophiliacs was the best available at the time and action was taken in good faith. Such treatments markedly increase the life expectancy, formerly 25 years, and quality of life of haemophilia patients. As soon as technologies, heat treatment and testing were available to improve safety, they were introduced. Evidence in relation to hepatitis C emerged over time, and the very severe long-term consequences of infection were only fully recognised by the scientific community during the late 1980s. Legal proceedings in relation to HIV were settled out of court on the advice of the Litigants' Council within the government, without the government being found liable. Special payments were set up for people infected with HIV who waived their right to take further action against the government. Although litigants won damages against the blood service in 2001 for the supply of whole blood that was contaminated with hepatitis C, this was under the Consumer Protection Act 1988, under which companies have strict liability for the supply of defective products. It did not imply negligence, and the present government resisted calls for further funding until Scotland decided to make hepatitis C payments in 2003, when England followed suit. So those are there you are setting out the government position. And I just wanted to ask you about the first three bullet points. So the treatment given to haemophiliacs was the best available at the time and action was taken in good faith. So the inquiries looked at this line to take, if you like, in a number of documents over the years. But I just wanted to take you to part of the Archer report and then ask you a question about this line to take. So if we could have, please, ARCH 601. And if we could go, please, to page 61 of that report. So here we've got, this is from chapter 7, so here we've got Lord Archer discussing the doctor-patient relationship, and he starts it off by saying the inquiry heard many complaints that during the 70s and 80s, patients were often not given adequate information about the options for their treatment and the associated risks. In particular, concerns were voiced about the paucity of information given to many patients concerning the following issues. One, the growing concern in the late 1970s among doctors treating haemophilia patients about the possibility that blood products could transmit harmful viruses and the uncertainties existing in this area. Patients were often not informed about these anxieties until late in the day, if ever. And then two, the relative risk of treatment with different blood products, notably the comparative risks of cryoprecipitate and factor VIII concentrate. Therapy was also available in the form of DDAVP, which did not involve the use of blood products. This analogue of vasopressin could be useful in the management of less severe bleeds, but was effective only in patients with mild haemophilia. Hemorrhages in patients with haemophilia varied from relatively minor to life-threatening. The relative risks of the bleed and its therapy varied accordingly, but several witnesses stated that this was often not explained to the patient before a choice of therapy was made. For instance, Mr. Stephen Wintle, the husband of Mrs. Colette Wintle, who suffered from a mild form of haemophilia and who had been treated with substantial quantities of US concentrate, go over the page, posed the question to the inquiry, then why was a high-risk product on a low, why use a high-risk product on a low-risk patient? Mr. Name redacted told the inquiry, if I had the choice to use factor VIII with the risk of infection with 3 life-threatening viruses or the choice of joint damage and arthritis, I would, of course, have chosen the latter. I was never given any choice. So that's what Lord Archer says at that stage. Can we go over to page 105 as well, please? In fact, we better start at page 104. So this is chapter 11 from his conclusions. And if we pick it up, please, over the page. The middle paragraph there, the anger and sense of betrayal still present among the haemophilia community was a frequent theme stated by witnesses to the inquiry. A common cause for resentment was the inadequacy of information presented to patients by their doctors. This is understandable given the medical mores of that time, refers to chapter 7. Nevertheless, it highlights the deficiencies of a paternalistic approach when doctors have to operate from an inadequate information base. And then the next paragraph deals with testing without knowledge. I want to pick it up at the bottom of that paragraph, please, where it starts 4 lines up from the bottom. The prescription of products carrying potential risks for patients with mild haemophilia when safe therapy with DDAVP was available was ill-advised and sometimes led to serious consequences which were avoidable. And then he goes on to say, we do, however, realise that the potential seriousness of hepatitis C was not then known, while understanding of AIDS was rudimentary. So I just wanted to draw your attention to those passages and ask you this. In setting out the departmental line, which, as I say, has a history, did you give consideration to updating the ministers about the findings that Lord Archer had made, which at least threw into question that departmental line?
I honestly can't remember what the considerations were at the time and whether we did in fact take into account Lord Archer's comments in his report.
So is this right? You may have taken into account Lord Archer's comments in his report and decided to dismiss them and continue with the departmental line.
Yes, I don't think dismiss is quite the right word, but
not accept them.
Not yes.
Even in those circumstances, given that you're briefing the ministers for a meeting with Lord Archer, would your practice, or would you not set out what what the weaknesses of that departmental line are to fully brief the
I
minister?
would say that would be normal practice, certainly, yes.
And then if we can turn back to that a document we were looking at a moment ago, please, MHRA 0024725. And if we turn back, please, to page 2 and look at that second bullet point. Such treatments markedly increase the life expectancy, formerly 25 years, and quality of life of haemophilia patients. Now, do you recall, or did you know at the time, anything about the role that cryoprecipitate took in increasing the life expectancy of people with haemophilia? I can't remember precisely what I knew at the time. I've certainly since remember being aware of the fact that cryoprecipitate was used, but that it required hospital treatment, as far as I understood, rather than being administrable at home. And do you think, again, if you had known at the time about the role of cryoprecipitate, that you would have included that in the sort of briefing to the ministers to say, this is the departmental line, but this is the argument against it, or this is the weakness in the argument? I think that's fair. I think that what we were setting out was, if you like, the current position of the government and previous governments. I think perhaps we hadn't taken account of some of the arguments or some of the points in Lord Archer's report, but I do think there are some subsequent briefings that actually do try and draw attention more to those.
Just on that answer, this is not just setting out the previous government's position according to the language which is used, is it? Because the opening paragraph says the position of the government, this and previous governments, is that this is a tragedy, is every sympathy for those infected. Then this is the introduction to points. It is important to remember the following points, which appears to be giving the following points current credence, as opposed to simply saying this is the previous line.
Yes.
Before I go on to ask you about the third bullet point, I just want to ask you this. The inquiry heard evidence from a long-standing campaigner last week, and one of the things that she said was that no matter how much evidence and new information you gave the Department of Health, they just didn't change their lines to take. I mean, she didn't use the word lines to take, but they didn't change their stance. Was that a feature of departmental thinking at the time that you were in post? That the lines to take were pretty entrenched, and it was people weren't going to shift almost irrespective of what was presented to them.
I don't think that's fair. I remember that certainly during my time in blood policy, we updated lines on many occasions. Now, I can't tell you specifically what those lines were, but I know that they were regularly reviewed and updated. But I would also say, in fairness, that government position had been held for many, many years, and I think these things do become embedded in one's mindset, one's thinking. I'm not making any excuse for that or excuse for that, but I do think that is something that is clearly evident.
And is a feature of that the length of time that the policy's been held? Has that got something to do with how entrenched?
I suspect it is. I suspect it is. That's right. It's a long-standing view, if you like, opinion of the department. I don't know whether entrenchment is quite the right word, but certainly embedded. It becomes part of it's almost hardwired into your mindset, I think. And I think there are quite fairly occasions when we should have been more critical of that than we were.
Would the words received wisdom be appropriate?
Possibly, yes, yes. That's, I think that's a fair way of describing it.
And then, again, coming back to this document, to the third bullet point, I'm sure you can anticipate my question in relation to that. The line to take there, or the point to remember there, as soon as technologies, heat treatment and testing were available to improve safety, they were introduced. Now, we've already looked at a document this morning, I think that you authored a few days earlier, in which you had pointed out to Dawn Primarolo that there'd been this judgment in A and others where Mr. Justice Burton had found that actually surrogate testing and hepatitis C testing ought to have been introduced earlier. So again, the same question, ought that have been brought to the attention of the ministers?
It was actually brought to the attention of ministers a little bit further down that same paragraph. But I do agree that it could have been explained in more detail so that ministers understood the issue of surrogate testing.
Because that paragraph there, we're looking there at the penultimate bullet point, makes reference, doesn't it, to the litigation?
Yes.
But it gives the impression, I mean, certainly there was no finding of negligence, but it gives the impression that there was no, criticism's the wrong word, but that there was a finding that they could and should have done something earlier.
Yes.
Obviously, that doesn't sound in fault in law, but that's not clear from that bullet point, is it?
No, I agree it's not.
Can I then pick up this at page 6 of the report? So I think we better. So we've got.
By the report, you mean what?
I'm sorry, the submission. Beg your pardon. So just to orientate ourselves in this submission. So we've looked at the submission. We've just come to the end of the submission. Annex A is the summary of Lord Archer's report's findings, and we're now looking at Annex B, entitled Reports, Conclusions and Recommendations, which is referring to Lord Archer's conclusions and recommendations. You set out there the summary of conclusions, and then you say full public inquiry should have been held much earlier. Early achievement of UK self-sufficiency in blood products would have significantly reduced the scale of transmission of infection to patients. Doctors must involve their patients when making difficult clinical decisions. Commercial priorities should never again override the interests of public health. So that's your summary, is it, of Lord Archer's conclusions?
Yes.
Then you've done a summary of recommendations, which I don't think we need to go to. And then you've, it's this part, detailed recommendations and initial response I wanted to ask you about. So you make the point that several of these recommendations are based on measures that have been implemented in the Republic of Ireland, notably establishment of a statutory haemophilia committee, establishing an insurance scheme for affected patients and a generous compensation scheme, which we understand averages around £750,000 per patient affected. And then you say this: the situation in the UK is different to that in Ireland, where it was acknowledged that action to reduce the risk could have been taken earlier. The Irish Blood Service issued an apology acknowledging failures in the past, and their payment regime reflects this admission of mistakes. Now, just looking at that, would you accept that while, of course, there hadn't been any judicial, well, there hadn't been an inquiry, so there hadn't been any findings of fault in respect of any government decision making. We know that a High Court judge in the Hepatitis C litigation, the A and others litigation, had found that screening could and should have been introduced earlier. Lord Archer, as you set out in this annex had found that early achievement of UK self-sufficiency in blood products would have significantly reduced the scale of transmission of infection to patients. So just and bearing in mind that those are the only two instances at which government decision-making have been held up to public scrutiny, bearing that in mind, could it really be said at this stage that the situation in the UK was different to that in Ireland?
We believed it was at the time that we put this briefing up, knowing what we did about the circumstances in Ireland. So I think this reflected our understanding of the situation at that time.
And I'm going to come on again to ask you a few more questions about the departmental position about that. So we can leave this document now, and just for completeness, we don't need to turn to it, but there is a record of the meeting between the ministers and Lord Archer, and for the transcript, that's DHSC 5277959. Can we turn now to this document? It's DHSC 5564474. Now, if we turn over to page, in fact, we'd better, turn over to page 2, please. We can see that this is an email from Penelope Irving, so that she's in the office of the Secretary of State, dated the 13th of March 2009, to a number of people, including yourself, and it is addressed to all, and it's following up from the meeting that we with Lord Archer, and the following, it sets out what was discussed there. And if we go about halfway down the page there, we can just see the Secretary of State would need to be convinced that current financial arrangements were insufficient before he considered any adjustments to the compensation scheme. Lord Archer explained that many patients suffered financial hardship, but MSPH said it was important to distinguish what financial pressures were a consequence of infection as opposed to being the consequence of the illness which had caused the patients to need transfusion in the first place, i.e. haemophilia. So that's a summary there of what was said in relation to that. And if we, it's over the page that I just want to get your evidence about. At the end of the summary, we have then, in terms of next steps, SOS and MSPH would like to receive advice on the following points. They would like to look at the eligibility criteria for those who receive money under the different schemes, including options to rationalise the schemes, which should incorporate the options already outlined on how and if to adjust compensation, and then what the options are for insurance provision, the department regarding insurance provision, and looking at funding of the Haemophilia Society. So I just want to try and understand the process. This is what we see sometimes, is it? We see sometimes the referral to a submission being commissioned. Is this a commissioning note,
yes.
A commissioning request?
Yes, it is a commissioning request, that's right, yes.
And so what we don't have in here is a request to look at what Lord Archer was, one of the recommendations Lord Archer made, which was for compensation to be awarded on a par with, at least on a par with Ireland.
Yes.
Does that mean for a civil servant receiving this that you are bound by what's in the commissioning note and you wouldn't then include within that submission something that you think should be in there or could be in there?
I'm not quite sure that it's absolutely black and white. I mean, certainly we would need to deal with primarily the issues that are in the commissioning note. But that wouldn't mean that we could not, if we had information and if we had the time available, supplement with further material if we felt it was relevant. But obviously the primary function there is to deal with what's in the commissioning note.
And can we take from this, or can you recollect that whether or not the Secretary of State was against parity with Ireland, or even looking at parity with Ireland? That was something that was discussed at that stage.
I cannot remember in terms of timing whether it was specifically at this meeting or whether it was subsequently, but I think there is certainly something in writing, perhaps a little later on, that makes it clear that ministers were not considering parity with Ireland.
At least I haven't seen any analysis by the department, by civil servants in the department, looking at what that would cost in any detail. Is that right? Is that your understanding, that it never really got off the starting blocks, that particular?
We did, and I believe it was a little controversial at the time. We did a very rough estimate to give ministers a sort of ballpark idea of what was being considered, or what the implications were of parity with Ireland. And the figure, I can't remember the precise figure, but it was very large. So we had put that to ministers as an indication of what they might be looking at, but I think we made very clear that we would need to do further work to actually, try and expand on that, really.
So it was never worked up into a serious option. Would that be fair?
Not at that stage, no.
Can we then pick it up a little later in March then with DHSC 0041157 _ 035. So if we turn, this is the first page and it's got a sticky note on it, but we get the first page again at page 2. So we can see that this is a submission from you to the Minister of State for Public Health, dated 31st of March 2009. And it's entitled Further Advice requested on 2 recommendations from Lord Archer's report on patients who contracted HIV and or hepatitis C through NHS treatment with blood products during the 70s and 80s. And then you say you've requested further advice into 2 recommendations made by Lord Archer. The recommendation to uplift the level of ex gratia payments currently made to those affected and their dependents, together with a change to some eligibility criteria and a revision of the mechanism by which payments are made, and also a recommendation in relation to the Haemophilia Society. I'm not going to ask you about that. So then just going down this page, we've got the financial relief schemes, and you set out there the Minister's preferred approach. So presumably there's been dialogue with the Minister, whether in writing or at a meeting, and you understand this to be the Minister's preferred approach. It's to replace the discretionary element relating to ongoing payments made by the Mcfarland and Eileen trusts with recurrent fixed payments. And then you set out who the trusts support. And it says at the bottom there of that paragraph, you would also like to see the level of recurrent funding for the MFT and ET increased. And then you set out in the next paragraph the discrepancy in the level of initial lump sum payments paid to beneficiaries of the Mcfarland Trust and the Eileen Trust. And you say you've included a proposal to harmonise those payments. And then at B, the preferred approach includes to bring the eligibility criteria for the Skipton Fund, which makes payments in relation to hepatitis C infection, in line with those for MFT and ET. And then you set out there that widowers and dependents of those who died before the Skipton Fund was announced on the 29th of August 2003 were not eligible for any payment. And you say any proposal to amend the Skipton Fund would need to be agreed by all UK health ministers as the devolved administrations contribute to the funding. And then at paragraph 3, you say the options that you requested we examine for amendment to the financial relief scheme are presented at Annex A, and we will have a brief look at Annex A in a moment. And then you set out in a table the summary of one-off and recurrent cost implications of the proposed changes. And then at 4, you say this: Finance advises that reaching agreement both with DH and with Treasury and the devolved administrations over any financial implications will be challenging. As announced at the pre-budget report, Treasury will allocate £5 billion in additional efficiency savings across departments in the budget in order to reduce public spending. They will be particularly concerned at any increase in spending in 2010, 2011 and beyond, both because of the wider fiscal position and because these can represent long-term commitments crossing multiple spending reviews. Both DH and the devolved administrations will face the challenge of reducing spending elsewhere to meet any additional costs, as even if they agree to these proposals, Treasury will not provide any additional funding. You asked whether additional funding for the financial relief schemes could be paid in instalments to ease the burden on central budgets. However, finance colleagues advise against this for the above reasons. So here you are sketching out what the Minister has told you is her preferred yes. option, but giving her a warning about the fiscal reality of yes. any increase in spending. Is that how to do this?
No, that's correct, yes.
Now, can I just take you over to Annex A, which we'll just have a look at briefly at page 9, please. No, over the page, please. So we've got Annex A, and here it's called Options for Revising the Mcfarland Trust and the Skipton Fund. And we can see one, you've given the detail there about the harmonising the payments between the Island Trust and the Mcfarland Trust. Don't need to look at the detail of that. It's there set out, and you give an estimated one-off estimated costings. And then at 2, you say you do the same in relation to the removing the discretionary payments and increasing the recurrent funding for Mcfarland and Eileen. And I just wanted to ask you about this. And the reason for going to this is to trace through with you the thinking that led to the announcement of annual payments of £12,800 for those infected with HIV. So you say currently all the recurrent payments made by the 2 trusts are discretionary, although the trustees have chosen to make a number of seasonal or annual payments which are paid automatically. And if we miss out a few lines and go down to the trustees estimated that over 80% of their disbursements went on regular monthly or annual payments, which were made to virtually all registrants and those bereaved households who qualify. On this evidence, it should not be a complicated matter to devise a scheme whereby these payments become non-discretionary, but the trustees and possibly representatives of the beneficiaries would have to be involved in developing the details. And then if we go over the page, you say this: the combined recurrent funding to the MFT and the ET is approximately 3.8 million, including administration costs. This provides payments on 2008 figures to some 562 MFT beneficiaries and 22 ET beneficiaries, a total of 584. Broadly, the average annual per capita payments equate to £6,400 per annum. If ministers agreed to raise the per capita payments to, say, £10,000 per annum and remove the trustees' discretion, this would cost around £5.9 million per annum, a recurrent increase in £2.1 million per annum. Now, I just want to try and understand where this figure of 6,400 comes from. Is it right to understand by my calculations that if you divide 3.8 million by 584, you get a little over 6,500, and you've perhaps knocked off £100 to represent the administrative costs.
But don't you have to take into account the 22 ET beneficiaries as well?
Yes, so
604. Sorry, 584.
Yes, sorry, did I say 5? That calculation is 3.8 million divided by 584 comes up at about 6,500.
I see.
Yes, I must admit I have not done the maths that you've obviously done sort of just now, but as I understand it, because I believe this was done by my colleagues who dealt with the financial payment scheme, I believe that's where the figure came from. I have no idea whether £100 was knocked off for administrative costs. I couldn't comment on that. But that's where that figure came from. It was purely a sort of an average payment across the board.
And would you accept that the average payments that were in fact made to those beneficiaries may have been very different if there were a number of those beneficiaries who didn't qualify for those payments?
I would accept that that's correct, you know, as a matter of principle.
Yes.
I don't know whether it applied in this particular instance.
I should have made that clear as a matter of principle.
Just as a matter of observation, the 562 Mcfarland Trust beneficiaries, on the reading that I have of this, is that the document is looking at those who actually received payments as opposed to beneficiaries of the trust who didn't. Because the trust deed itself provided for a wide range of beneficiaries who did not, it would appear, receive any form of finance during the year in question.
Yes, my understanding of things at this time was that very few non-infected but potential beneficiaries actually receive payments. So again, I think this relates to that number of beneficiaries that refers to the people who receive payment.
So, if you like, for beneficiaries as written in the third line, we should read beneficiaries in payment as opposed to those who were
in total.
In legal terms beneficiaries of the scheme.
Yes, that's my understanding.
But beneficiaries, so the payments we're talking about are the capital payments that were given to beneficiaries when they first joined the scheme.
No, I don't think so. This is the recurrent. These are the discretionary payments that are made. So
your understanding of that figure 584 is that those that qualified for the ongoing annual payments was 584.
Yes.
Then if we can turn to the Minister's response, I think this illustrates the point you were making earlier. DHSC 5567339. I think we can start this at page 2. So, just to orientate ourselves in terms of the chronology, we just looked at a submission dated the 31st of March. We're now looking at an email from Morven Smith to you dated the 6th of April, to you and Elizabeth Woodison. And it says, "Dear Liz and Rowena, thank you for your submission on the Archer inquiry recommendations." And then it sets out that in the submission in the current form, it does not address the Minister's concerns and sets out what the Minister's objectives are, a set of proposals she can present to Secretary of State as to what we can do to respond to the inquiry's recommendations. These proposals will need to give options of how to approach each recommendation, and then it goes deals with some of the recommendations which I'm not going to ask you about. And then if we go down to the bottom of that page, what the Minister would really like are options on how to respond to the Archer inquiry in the most positive way possible. She would like to see a submission which responds to her steers and to sets out the options she prefers and how they might be achieved alongside the pros and cons. However, she would also like to see further options which might also provide a robust response to Lord Archer's recommendations. And then recommendations are made by Ms Smith as to how you could structure the submission in a different way and set out pros and cons and so on. And then at the bottom, sorry, if we could go over the page, please. Yes, so a number of recommendations made about how to structure the note. I don't think we need to go through those. And thank you for looking again at the financial questions around MFT, ET and SF. The Minister will provide these alongside other options in a revised submission. And then wanting to know what other cons and pros there are of the different options. And then if we see what happens subsequently, we can see DHSC 0041307_021. We can see that this is a minute which is now being prepared by Liz Wooderson, who is
the director.
The director.
Yes.
So it's been escalated.
It has, yes.
And is that as a response of what you've described as this slightly unusual dialogue?
Yes, I think so. I think at that stage, and I don't remember the detail of the discussions that I had with my sort of senior colleagues, but the result was that Liz decided that she would put this submission to the Minister herself. So that's what happened.
And hence we don't have on this a cleared by, because of course she is one of the senior leadership team.
That's right.
And would you have had, given that you were involved in the detail of previous submissions, would you have had an input into this, or would she have done that entirely without your
She probably
input?
would have done it entirely on her own, but I would say that she would probably ask us if there was anything that she was unsure of or she wanted to check.
And you might do a read through of it or something of that sort. And we can see that the context in which this is being put to the Minister, we understand you're keen to respond to Lord Archer's report in the most positive way possible. We've sent several submissions covering different aspects of his recommendations. As requested, this submission now pulls together the position on each recommendation in response to the steers you have given us so far. So I wanted to just ask you about, I'm conscious that it's not your document, but because we see, I think for the first time, the figure of £12,800 in this document.
Yes.
Just wanted to get your views on that. If we go over to page 3, please. So, recommendation 6A, financial assistance should be increased and take the form of prescribed periodic payments. And she set out a number of options for the different funds. And it's the Mcfarland and Eileen Trust at paragraph 18. We can see it at paragraph 19. The first option is to provide every recipient with the same annual payment we would need to level up. And then a suggestion is given of £10,000 per year and what that would cost. And then it says you might prefer to double the current average payment from £6,400, and that's presumably the figure she got from your previous submission, to £12,800 per annum, and then sets out what that would cost. So is it right to understand that, I mean, we know that 12,800 was the figure that was ultimately chosen, but is it right to understand that that figure was arrived at by looking at what had been given, doubling it?
Yes.
Is it fair to say that that was done on the basis of what was affordable and that politically the ministers could live with?
Yes.
Rather than what is the need of this cohort and how do we meet it?
Yes. At this stage, there was no assessment of need. Certainly subsequently, we tried, with further reforms, we tried to incorporate assessment of need as far as we were able to. But at this stage, it was arbitrary, and it was done on the basis, as I remember it, of affordability.
And I just want to pick up on a point that I'm going to come back to later at page 4 of this, just to draw your attention to what's said at this point. So one of the things that you've been asked to consider, or she's being asked to consider, is anomalies between and within schemes being removed. And paragraph 22, Skipton Fund, the most significant anomaly is that partners and dependents of those who died from hepatitis C before 29th of August 2003, when the fund was set up, do not receive any payments. And then you say you don't know how many people that applies to, and then she gives an estimate of a cost. And then she sets out the pros and cons of dealing with that anomaly. This is pros. This is by far the most significant anomaly, and correcting it will be welcome. Cons: it is a very large sum, and reaching agreement with HMT, Her Majesty's Treasury, and the DA, the devolved administrations, would be challenging. Finance colleagues advise that it is not impossible, but that you would need to make a strong case to Secretary of State. Secretary of State would need to be convinced as to why this should be funded over and above other pressing priorities. And it says this: the funds would have to be spent this year, i.e. 2009-2010, as there would definitely be no money next year. This would be difficult to achieve, as we do not have contacts for these people. We would publicise the scheme through appropriate channels and invite them to come forward, which in itself could be a problem, as it could mean the scheme was vulnerable to abuse and false claims. And it says, and then this makes the point that this option would not address anomalies between the schemes, because Skipton Fund beneficiaries would still not receive annual payments as the Mcfarland and Eileen trusts do. I just draw your attention to that now, because that's something we'll come back to, and it's something that you address in your witness statement. Now, we don't need to go to this, but just to complete the picture, and for those that want to follow this, Dawn Primarolo makes a recommendation to the Secretary of State, Alan Johnson. Again, this is just for the transcript, WITN 4688069, in which she sets out a package of measures, which were the ones that were ultimately announced. And if we look at the announcement, just so that everybody's clear as to what that was, it's DHSC 0015670. Government response to Lord Archer's independent report on NHS supplied contaminated blood and blood products. Is it right to understand from your witness statement that you were involved in the drafting of this document?
Yes.
And if we go then, please, to pages 10 and 11, we can see the response to recommendation 6 at the bottom there. Financial assistance should be increased and take the form of prescribed periodical payments. And then if we go over the page, we can see in detail what's being announced. Second paragraph, going to increase the funding to the trusts, Mcfarland and Eileen, and say current average annual payment is around $6,400. We intend that in future payments of $12,800 per annum will be made to each infected individual, thus eliminating the need for them to make repeated applications. And then yes, so, and then I now can't find it. Yes, it's here, sorry. And then if we go down the page, we can see the Skipton Fund will continue to make payments to people infected with hepatitis C, and I commit to reviewing it in 2014 when the fund will have been in existence for 10 years. So announcements in relation to payments for those with HIV, but the decision about doing anything about those with hepatitis C is effectively put off until 2014, right. Is that
yes.
right? Was that on the grounds of affordability?
My understanding of it is yes, it was, given the figures that we put to ministers.
And were there concerns expressed, do you recall, about the fact that this was going to widen the gap between what those with HIV were receiving and what those with hepatitis C were receiving?
Yes, I don't remember any specific discussions, but I think, I mean, there were many concerns about, or many discussions about the pros and cons of the various options. I think this was felt to be the best under the circumstances, but clearly not perfect.
And under the circumstances means what?
Fine. Well, given the financial constraints. Ministers had little flexibility to do more.
So even with a minister such as Dawn Primarola, who was, she wasn't in post at this stage, I know, but pushing forward,
yes.
Even in those circumstances, the financial position was difficult.
Yes, yes, it certainly was, yes.
I think I might have just said something wrong, actually. I think she was in post at this stage. She was,
yes.
Dawn Primarola, sorry, was in post at this stage. Is that your recollection?
Yes, can you just remind me of the date of this again? This was May,
yes.
Wasn't it? May 29. So yes, she was in post. I think that's
this
right.
Is, yes, 20th of May 2009.
Yes. Yeah.
So I'm going to move on now to events post this announcement. I'm going to pick it up on the 2nd of June 2009, so a couple of weeks after the announcement of the that we just looked at. DHSC 0041219_077. And it's in fact page 2 is where the document that I want to look at starts. We can see this is from you to the Minister of State for Public Health, again still at this stage Dawn Primarola, and it sets out the next steps after the government response to Lord Archer, and it sets out some information about the reaction. So you say this: reaction to the government package announced in response to Lord Archer's report has been limited but negative, and then it sets out the main area of criticisms there about the level of payments that have been announced. And then at paragraph 2, you have asked us for more detailed information as to why the situation here is different from Ireland, together with possible options for handling the criticism around the Skipton Fund. And then you go on to set out why Ireland is different. And you say this: the government here has never accepted any liability. We believe that people were offered the best treatment available at the time, and that as soon as blood screening tests were available, they were implemented. I'm not going to ask you about that again. I've already asked you about that. And then you say there were attempts to bring litigation against the government and set out what happened in relation to that. And then you say payments for all these funds are ex gratia goodwill payments only. And then you make some comments about the level of payments at the Mcfarland and Eileen Trust. So that's the government position in England. And then if we go over the page, you say this: in Ireland also, the state did not explicitly admit liability. However, contrary to the position in the UK, the Irish Blood Transfusion Service was found by a judicial inquiry to have been responsible on 2 occasions, 1977 and again in 1991, for failures which resulted in the large-scale contamination with hepatitis C of a blood product used to treat pregnant women. This finding resulted from the IBTS's failure on both occasions to follow its own guidelines that blood from previously transfused individuals should not be used for the preparation of products because of the increased risk of infection. The report of this Finlay inquiry concluded that wrongful acts were committed, and the Irish government therefore, and I stress the word therefore, set up a hepatitis C compensation scheme in 1997 for the infected women. Following this conclusion, and because of the threat of litigation, which the Irish government believed it would lose. And then you say the compensation scheme was later extended to all people infected with hepatitis C through blood products and blood transfusion, as some infected women had donated blood and thereby infected others. And then you refer to an answer given by Lord Warner. So I think you've already said that this was a view that was commonly held in the department. So you would have got this from what, discussions with other colleagues, looking at previous submissions and the like?
Yes, I imagine so. I don't remember precisely what the source was, but this was our understanding at that time of the situation in Ireland.
And you are aware, presumably, that ultimately this was held after you wrote this. After you wrote this submission, I stress that it was held by Mr. Justice Holman in a judicial review.
Yeah.
The departmental line, that it was as a result of criticisms or findings of wrongful acts on the part of the Irish government that a hepatitis C scheme was set up, that was wrong.
Yes, that was the judgment.
Yes, and for those that want to look at that judgment, I'm not going to put it up now. It's PRSE 303333. When you wrote this, so this is before Mr. Justice Holman had looked at this in detail and come to his view. So when you wrote this, can you recall whether you were aware of campaigners, those that had been infected, others in that community, if I can use that term, challenging this narrative of the departmental line?
I don't recollect that, I must say.
Can you help us with how it is that this line to take, if you like, could have this ultimately was wrong, could have survived so long in the department and led to what Mr. Justice Holman found to be wrong statements being made to Parliament, inaccurate statements being made to Parliament?
Yeah, yes, I can't help you with that. I don't know the history of this, but as you point out, we referred to an extract from a question that Lord Warner answered, or a statement that he made in 2004. It seemed to us, certainly as we understood it, this was the position.
And I appreciate that you can't recall whether or not you were aware that this narrative was being challenged, but would that, if we sort of, do you think that if campaigners, for example, were challenging a line to take as being inaccurate as a matter of fact, that might, or that should be something that would call for someone at the department to actually look at this and say, is this actually right?
Yes, I do.
Now, I'm not going to ask you any more questions about what led to that judicial review we've just talked about, because you've made it clear, and I think the documents bear out, that was led by your colleague Debbie Webb.
Yes, that's right.
Not by you. So while I think you say you were cited on what was going on, kept up to speed, that wasn't you weren't leading on that issue.
No, that's right.
Now, just continuing the chronology then, we've just been...
Just before you do that, I wonder if I could ask something about the document which is on the screen. The handwriting on the left-hand side, is that Morgan Smith's?
That's my I would agree that it looks like her.
But it's yours, is it?
No. It's certainly not my handwriting.
That's right. So it looks like hers. Now,
Yes.
if we just have a look at that, she seems to think that the introduction of heat treatment in 1985 removed the hepatitis risk from blood products. Would you have any idea where that idea came from?
I can only... No, I have to say so. I don't know where she might have got that from. I hadn't seen this document annotated with anybody's, handwritten comments or any of these documents annotated, obviously until the inquiry supplied them. So maybe she had referred to some of the documents to which Council referred earlier. I don't know.
It's certainly something which has been said more than once in documents which we've been looking at recently. It doesn't, I think, correspond with other evidence which the inquiry has thus far had about the likelihood that any product which came to the United States would not have been, for at least for a significant time after 1985, adequately proofed against hepatitis. HIV might be different, but hepatitis is what this deals with. Do you recall that being the position, or is this something which you didn't really pick up?
I don't know. I don't recall knowing that at the time. Maybe I picked it up later.
I mean, certainly, it's an example, perhaps again, of an idea taking hold and not being significantly questioned subsequently. This is not your idea, right?
No.
I'm asking a comment on what the private secretary had in mind.
Yes, possibly that is the case. I noticed that she does mention the UK introduced Hep C testing of donations, so obviously she wasn't thinking, I guess, about the commercial products at the time.
Yes. Thank you.
And so just then picking up on the chronology, so just reminding ourselves that this was a submission that you wrote on the 2nd of June 2009, that shortly after this, Dawn Primarolo was replaced by Gillian Merron as the Minister of State for Public Health. And there's then, which I'm not going to go through, submissions and work done and so on, in relation to making a decision about whether or not the review announced in May 2009 of Skipton, due to be in 2014, should be brought forward. And the ultimate decision was it should be brought forward.
Yes.
And that was announced, and again, we don't need to look at that, but that was announced by Earl Howe in a written ministerial statement on the 14th of October 2010, and that is at DHSC 0006626. And it's that I want to pick up with you now, the Skipton review in 2010. You tell us in your witness statement that you led the review work on that
Together
review.
with Dr. White, yes.
So from that we understand it's an internal departmental review, albeit with some assistance from outside experts.
Yes, that's right.
So if we turn up then, please, the final document that was produced, it will give us the terms of reference and the process and so on. It's PRSE 304024. So here we have it, the review of the support available to individuals infected with hepatitis C and or HIV by NHS-supplied blood transfusions or blood products and their dependents. And we can see the terms of reference at page 3. Background is set out paragraph 1 that I've just mentioned, that the announcement of that review, 14th of October 2010, and the scope of the review is at 1.2, to review the following aspects of provision and support for those affected with HIV and or hepatitis C via NHS-supplied contaminated blood and blood products. A, to review the level of ex gratia payments made to those infected with hepatitis C, including the consideration of financial support for their dependents, the eligibility date for entry to the current scheme, comparison with the ex gratia payments made in the UK to those infected with HIV and their dependents, and then B, to review the mechanisms by which the ex gratia payments for HIV and hepatitis C are made. And then there are a number of other parts to the review which I'm not going to focus on, but just to set them out here, consider the provision of insurance for those infected, to consider the issue of prescription charging for those infected, and the provision of access to nursing and other care services in the community for those infected. So it goes beyond, is it right, the Skipton, a review of the Skipton fund that was announced.
Yes.
And what we see
Little
here,
beyond.
And what we see here is some of the issues and recommendations from Lord Archer being picked up and looked again formally by the department.
Yes.
So then, if we turn, please, to page 9, we can see a little about the process. Section 3, the review process. The review was conducted by the Department of Health, supported by input from relevant external experts, including the chairs of the Mcfarland and Eileen Trusts and the Skipton Fund. And then scientific and clinical advice on hepatitis C and HIV was obtained from a joint working group of the advisory group on hepatitis, the expert advisory group on AIDS, the UK Haemophilia Centre Doctors Organisations, the Hepatitis C Trust, and the Health Protection Agency. And then the scientific and clinical review of the evidence base is at Annex 4. And if we just turn to page 58, which is the end of Annex 4, we can see the membership of the expert working group. So we've got 3 advisors on hepatitis, 3 expert advisory group on AIDS, and then over the page we've got UK HCDO advisors, Health Protection Agency, and the Hepatitis C Trust. So turning back then, please, to page 9. We can see is this right, that is the group of expert advisors referred to in paragraph 3.2?
Yes, yes.
I think it's right that we don't know who the external experts at 3.1 were, but you've named the chairs of the Mcfarland and Eileen Trust and the Skipton Fund. Was there anyone else that you can recall that was involved under the 3.1?
No, I think as far as I recollect, it was those individuals plus those at 3.2.
And then we can see what the various other parts of the review are set out at 3.3 and 3.4. 3.5 refers to meetings between representatives of affected communities with Anne Milton and with campaigners. And then paragraph 3.6, the conduct of the review was based on the scope set out in the terms of reference and the following principle: to reduce the current anomalies between HIV and hepatitis C payment schemes and avoid the creation of new anomalies, to ensure the review is evidence-based where evidence is available, and if we go over the page, that payments are made in recognition of the special circumstances of these individuals as a result of their infection and their financial need. So the terms of reference we looked at being applied through these principles, is that how it works?
That's right.
And then if we look then at section 4, which starts at page 11, this is a summary of the expert scientific review that's set out in an annex. But is it right to understand that the evidence base for the review was what you were being told by the expert group about the infections themselves, the impact they had on people's lives at various different stages.
Yes, that's correct. But they were based on a review of the scientific literature, which was undertaken, if I remember correctly, by the Health Protection Agency.
And so we can see at paragraph 4.2 that the expert and scientific advice was sought from the joint working group, and then you set out a summary of the review report, and you, if we go over the page, you draw some conclusions from that evidence base, and we'll pick that up at paragraph 4.8. The lack of morbidity associated with acute hepatitis C infection supports the current position that individuals who experience acute infection and do not progress to chronic infection should not receive financial support. The evidence does not support a strong case for making a change to the current Skipton Fund Stage 1 payment for all individuals with chronic hepatitis C infection, as this payment is designed to take account of the range of symptoms caused by hepatitis C infection, as well as the side effects of treatment. Nevertheless, some individuals may experience financial hardship in this phase of the disease, particularly if they are unable to work during periods of treatment. The development of serious liver disease or B-cell NHL associated with chronic hepatitis C infection will substantially reduce quality of life and have an impact on life expectancy. Therefore, there is a strong case for improving the current provision for payments to this group. So you're effectively, there's been a review of the science, has been advice from the expert committees about the impact of these infections, and these are the conclusions that you've drawn as a result of that.
That's correct.
And then if we go over the page, please, we can see the next section. Payments for hepatitis C infection, and here you are reviewing the payments that are currently being made, setting out what the discrepancies are, and so on, and then at the bottom of the page you start looking at the options. I want to pick it up over the page, please, at paragraph 5.6. The expert scientific review presented evidence that indicated that the current Skipton Fund Stage 1 payment level is appropriate for those with chronic hepatitis C infection, but that some individuals might experience additional financial hardship, particularly if they cannot work during prolonged course of treatment. The introduction of needs-based discretionary payments for these Skipton Fund Stage 1 recipients should be the best way of targeting resources at those in greatest need. And then you set that out as an option. And that, we understand, is it right to understand that that's what eventually became Caxton Foundation?
Yes.
And then 5.7, the expert scientific review demonstrated that those with serious hepatitis C-related illnesses may have a reduced quality of life and significant morbidity and mortality. The evidence supports an increase in the Skipton Fund Stage 2 payment, and you set that out at option 1.2. And then you go on to look at providing recurrent financial support for Skipton Fund Stage 2 recipients on the basis of the evidence that you've received. And if we turn over to page 5.11, we can see what you say there. However, an advantage of setting the level of payment at $12,800 is that given the current fiscal context, funding available could be most effectively directed at those in greatest need through discretionary payments. On balance, taking into account the aim of maintaining discretionary payments and overall affordability of the wider package of measures within the overall fiscal context, the review concluded that the flat rate recurrent payment should be £12,800. So is it right to understand that the need for increased Stage 2 Skipton Fund payments was evidence-based?
Yes.
The need for a recurrent annual payment for those at stage 2 Skipton was also based on evidence.
Yes.
But setting it at £12,800 rather than another figure was based on what was affordable and presumably the ministers could live with politically.
Yeah, and also to make sure that it was in line with what was given to those with HIV. I mean, we recognised at the time that it wasn't based on any assessment of need. We took legal advice on how to approach that, and it was quite clear that there were arguments for trying to do some sort of needs assessment, but equally arguments for saying, well, it would be better to try and make the hepatitis C recurrent payments equivalent to those with HIV, and so that's ultimately what we did.
So I've got one more point to pick up on this document, which is probably going to take me 5 or 6 minutes. So I don't know whether...
Let's do that, shall we?
So then if we can turn then to page 16 of this document, we can see at the bottom there that what you're doing in this section of section 5 is looking at the options for dependents or the estates of those who have died. And if we go over to page 17, we can pick it up at paragraph 5.18. And you're here addressing the concerns about those who had died before the 29th of August 2003 and had not received any payments because of the way that the Skipton Fund was set up before your time.
Yes, yes.
And 5.19, you say a key consideration in the implementation of that option, dealing with that, is the medical evidence needed in respect of those who died before the 29th of August 2003 in order to qualify for a payment in line with the current eligibility criteria of the Skipton Fund, since medical records may not be available. Therefore, it's possible that in some cases it may not be possible to provide the necessary evidence. It might be difficult or even impossible to make payments in all genuine cases without relaxing the requirements, which would introduce a significant risk of inappropriate claims. This is an identified risk, although the aim would be to strike the right balance between meeting genuine claims and avoiding inappropriate ones. So is it right to understand that you, from this, I don't know whether this is early on in the decision making, but certainly before the decision had been made about whether this cohort should be able to get money from Skipton, were identifying that very difficult evidential burden that they would have.
Yes.
And then bearing in mind that this is public money and one has to have some criteria.
Yes, that's right. We were trying to steer a difficult line and get an appropriate balance between the two. And we did recognise that hospitals did not always keep medical records, and that for some potential claimants it may be very difficult to demonstrate, evidence of infection through medical treatment.
And then at 5.20 we can see that you're looking at an option of introducing a new lump sum payment for bereaved dependents, including dependents of individuals who died prior to the 29th of August 2003, which would meet representations from campaigners. But you say at the bottom of that paragraph, the sums involved are potentially very large, because this would need to also apply to the bereaved dependents of all infected individuals, HIV and hepatitis C. And if we go over the page, in order to avoid creating a new anomaly, therefore this option was not taken forward.
That's right. We put that advice to ministers, and the decision was taken not to pursue that.
And then if we go to just concluding on this review, if we go to page 36, you set out the recommendations of the report and conclusions, and at 11.2 you set out what they are. Introduce a recurrent flat rate annual payment of £12,800 for all living Skipton Fund Stage 2 payment recipients. set up access to discretionary payments for those infected with hepatitis C by NHS-supplied blood transfusions and blood products, and for the dependents of infected individuals, including of those who died, targeted at those in greatest in need. And then 2, up-rate levels of this new flat-rate payment for hepatitis C, as described in 1, and the existing payment for HIV, in line with the CPI annually to keep pace with living costs. And then over the page at little 3, extend eligibility for stage 1 or both stage 1 and stage 2 payments based on the eligibility criteria of the Skipton Fund in respect of an individual who is infected with hepatitis C through NHS-supplied blood transfusions or blood products, who died prior to 29th of August 2003, claims to be registered by the end of March 2011. I'm going to come on to ask you some questions about that last sentence. And make a further payment of £25,000 to those who receive a stage 2 payment from Skipton Fund. And there are various other recommendations about the other aspects of that review, which I'm not going to ask you about. And it's right to understand, is it, that all of those recommendations were ultimately accepted by the ministers. And you've set out, just to conclude on this issue before we break for lunch, you've set out in your witness statement, I don't need to go to it, but it's at paragraph 63.6 for those who want to, the process that you went through for this review. So you say, first of all, you went to the Parliamentary Under-Secretary for Public Health at the time, Anne Milton, and the Secretary of State at the time, Andrew Lansley, to get agreement about the internal departmental view. And then the Secretary of State goes to the Treasury and the Prime Minister.
Yes.
And then that, once that's all been agreed, you've got the money, you've got the support of the Prime Minister, then that leads to the announcement.
Yes, that's sort of fundamentally it, yes.
And again, we don't need to go to this, but just for completeness, Andrew Lansley's announcement on the 11th of January 2010, it can be found at ARCH 301478.
Could I just say something before we finish? I just wanted to, I mean, obviously we've done a quick overview of some of the documentation that's available this morning. I just wanted to explain that there is a great deal more documentation behind this whole series of events, starting, I think, with Lord Archer publishing his report, going right through to Mr. Lansley making the announcement for this review, and of course beyond that as well. There's a huge amount more material, and you know, if there's anything I can do to help explain some of that. I haven't seen it, I have to say, but you know, if it's made available, I'd be very happy to do so.
Yes, I mean, I should make clear, you've been sent quite a lot of material, but there is an awful lot of material you haven't been sent. And of course, I am just picking bits out to try and get us through within a day.
Yes.
Right. So we'll take a break now until 2:05. 2:05. Same rules apply, of course, during this break as they do in any